You know, when you think of a dispute between two of the world's friendliest neighbors, like the US and Canada, you don't exactly picture a war. But what happened here was a war of a different kind. This wasn't a fight over land or sea, but a quiet, super high-stakes negotiation fought with legal letters and arguments. A battle over the very rules of justice itself. Okay, take a look at this document. It's dated November 25th, 1981. And yeah, it might look like just another stuffy, formal letter, but it's not. This is actually the very first move in a delicate diplomatic dance at the world's highest court, a dance that would end up setting a huge precedent in international law. So here's how we're going to break this all down. We'll start with a dispute that brought these two allies to court in the first place. Then we'll get into the unique, kind of risky solution they proposed, the tough questions the court threw back at them, and the clever diplomacy it took to clear every single one of those hurdles. All right, so first, let's set the scene. You've got the United States and Canada, right? Close allies, sharing the longest undefended border in the world. But they had a serious problem. The whole thing was about their maritime boundary out in the Gulf of Maine, an area that is just packed with some of the best fishing grounds on the planet, not to mention a ton of potential for oil and gas. So yeah, the stakes were absolutely enormous. Now, instead of letting this thing get out of hand, they did what good neighbors do. They took it to a neutral referee, the International Court of Justice. But here's the twist. They didn't want just any old trial. They had a very specific and completely untested idea in mind. And this is where the story gets really, really interesting. See, the two countries didn't want the full court of 15 judges to hear their case. They came up with a novel solution, something that had literally never been done successfully before. They actually asked the court to form a special chamber just for them. Think of it like a custom-built mini court, hand-picked from the larger bench of judges, to deal with one thing and one thing only, the Gulf of Maine dispute. The hope was it would be more focused and, maybe even faster. So what's with the number 1 on this slide? Well, get this. According to the court's own registrar, this was the first time ever that a special chamber had been formed for a specific case since the court was founded back in 1946. They were sailing in completely uncharted legal waters. But you can't just walk into the world's highest court and start making up the rules. The court is the ultimate guardian of its own procedures, and it wasn't about to just rubber stamp a request this unusual. So it pushed back, and it pushed back with some very serious, very pointed questions. On December 18th, 1981, this became official. The acting president of the court sent a formal letter saying that some judges had raised concerns about possible incompatibilities between what the US and Canada were asking for and the court's own fundamental rules. This was a huge red flag. Okay, so the court laid out 4 really critical questions. 1, how would they fill vacancies if a judge had to step down? 2, why was their timeline tied to their own judge and not to when the court officially created the chamber? And, most importantly, they needed to be absolutely sure that the chamber's decision would be final and binding, with no chance of some other third party getting to review it later. This formal grilling from the world's highest court kicked off a really careful and coordinated response from both Canada and the US. What we see next is basically a masterclass in legal diplomacy, and it all happened through formal letters. And this just illustrates the whole back and forth perfectly. On the left, you've got the court's letter, laying out its tough, skeptical questions. And on the right, you see the start of the joint response from both countries, written so carefully to give direct, clear, and reassuring answers. So their joint response was super methodical. They went point by point and tackled every concern. They insisted their agreement was totally consistent with the court's rules, that it didn't step on the court's authority, and that the whole third-party thing was about a completely different issue. And crucially, they promised on the record that the chamber's decision would be final and binding, period. So it looked like the biggest problems were solved, and the court officially formed the chamber in January of 1982. But just when it seemed like they were ready to go, another, more personal problem popped up that almost derailed the whole thing again. This new issue was all about Canada's chosen judge, Professor Maxwell Cohen. Now, he was appointed as a judge ad hoc, which is pretty standard. It lets a country appoint a judge for a specific case if they don't already have one of their nationality on the bench. The problem wasn't that he was appointed. It was about his exact status on this brand new chamber. In March 1982, Canada's representative sent this urgent letter. They'd noticed that on a recent court order, Judge Cohen wasn't listed with the other voting judges, And that set off some major alarm bells. Canada formally demanded clarification, saying they were, and I quote, anxious to ascertain that their judge could participate on terms of complete equality. Basically, they were saying, hey, wait a minute, is our guy a real judge on this thing or not? Well, the court's registrar came back fast and left no room for doubt. Just 8 days later, he sent a response that directly quoted the court's own rulebook to give a rock-solid reassurance. Judge Cohen shall take part in the decision on terms of complete equality. He explained the name was left off because of 2 factual errors in the document, which would be fixed. The message was loud and clear. There are no grounds for anxiety. And with that final, definitive assurance, the last procedural hurdle was cleared. After months and months of just negotiating the rules of the game, the path was finally open for the actual case to begin. When you lay it all out like this on a timeline, you really get a sense of the whole journey. We're talking 5 months, from November 81 to March 82, of this careful back and forth, all through formal letters and nuanced legal arguments. And remember, this was all just to agree on how they were going to proceed, before a single argument about the boundary itself was ever made. So, after all that painstaking diplomacy over vacancies, timelines, and the rights of a single judge, the battle over the rules of the game was finally won. But that quiet victory was really just the warm-up act. It only set the stage for a much bigger conflict. And now, the real question remained. Who would actually win the Gulf of Maine?